This was Alvin Bragg right after he indicted Donald Trump. He came out and said, I'm indicting him for falsification of business records. People said that's a misdemeanor and the statute of limitations is expired. How can you bring that? He said, well, it becomes a felony with a longer statute of limitations if it was done, the falsification, to cover up an underlying crime. Then the press asked the question we all had on our minds. What was the underlying crime? What was he trying to cover up? And here is that moment.
34 felony counts of falsifying business records in the first degree. It is a felony to falsify business records with intent to defraud and an intent to conceal another crime. 34 false statements made to cover up other crimes.
And they were done to conceal another crime, but the indictment does not specifically say what those crimes were, what laws were also broken.
The indictment doesn't specify that because the law does not so require.
I don't have to tell you. I don't have to tell you. It wasn't until closing arguments yesterday when the prosecution got up second, because under New York law, unlike in most places, the defense has to go first and the prosecution goes second. And after the defense attorney had already sat down, that's when we finally learned what the underlying crime was. He got up there, and while he cast a wide net still, saying it could have been a tax violation, it could have been falsification of other records, like double falsifications, but really they're hanging their hats on the violation of federal election campaign law, campaign finance law, federal election law. It's called FECA, F-E-C-A. That's what the prosecution drove home. That's the principal basis for this entire case. He didn't want us to know because that's a federal statute. And Alvin Bragg, this DA, doesn't have the jurisdiction to enforce federal election law. The federal DOJ had already said there's no case here. The Federal Election Commission had already said there is no case here. Only Alvin Bragg resurrected this alleged violation as the underlying basis for this entire criminal case. And I'll ask you, Mark Eiglarsh, what kind of a position that puts the defense in a New York courtroom when they've already had to sit through the entire case without ever being told what the underlying offense is, and only when they're no longer allowed to speak does Bragg lift the dress up for the first time.
It nauseates me, and not because I'm a Trump lover, but I'm a lover of the criminal justice arena where like cases should be treated alike. I have never heard in 32 years of litigating cases, not knowing what the theory of prosecution is until after we rest our closing arguments. It's absolutely insane. Now, that said, and I'll take some heat for this anytime I ever try to keep it fair and balanced, I always get the ugly mail. I don't blame the judge for this. It sounded like you were blaming the judge and even the prosecution. It sounds like the law is the problem. The law in that jurisdiction, which allows them not to specify what specific crime, the to-wit part, which we see all day long here in Florida and in federal court. We know what exactly we're litigating. The law allows that to occur.
It doesn't matter. I don't give a shit what was written in the New York statute. There's this thing called the U.S. Constitution that requires due process. And the Constitution reigns supreme. The Constitution requires that a defendant has due process afforded to him before we throw him in jail, take away his liberty, or convict him of a crime. And there is zero chance any statute that allows the prosecutor to hide the felony all the way through closing would ever be upheld.
With you. Hold on. I'm with you. I told you, I think it stinks. But here's my question. Did the judge do anything unlawful? Did the prosecutors do anything that the law did not allow them to do by not revealing what specific crime it was?
Yeah, they do. They did, because they're, as you know, their obligation is the pursuit of justice. That's their obligation. It's not to get a conviction. And they did everything within their means to prevent Donald Trump, from knowing exactly what he was defending against so that they could surprise him, so that they could keep him off balance, and so that they could surprise when no one else could stand up on behalf of Donald Trump, say, This is a federal case. We're here, we're wolves in sheep's clothing. We're actually the feds trying to enforce this completely amorphous, difficult to understand statute after we've already kept out, through all of our arguments, any federal election law expert from testifying so this jury or any of us could understand the fundamental foundation of the entire criminal case.
I can't wait to hear what Arthur has to say on this. And Arthur, listen to what I said. Okay, it does suck, but is it unlawful?
Go ahead, Arthur.
Here we go, Arthur.
Mark, I am going to rely on my supreme leader when it comes to the law, who last night on a phone call with me uttered the same words that just came out of Megyn Kelly's mouth. For the prosecutor's job. My father.
Who's your supreme leader?
My father.
Your dad, okay.
Okay, he was a lawyer in the Frank Hogan's, in the Manhattan DA's office in the 60s and the 70s, and has practiced there for decades. Literally, he's been a lawyer over 60 years. He said the exact words you just said, Megyn, that the job of any prosecutor is justice. It's not just to obtain a conviction. And Mark, I will tell you what is standard operating procedure here in New York. There is a bill of particulars. And for those people who don't know what that is after a defendant gets charged with a crime, you request a bill of particulars. And what you're asking for is, what are the particulars? What are you saying my client actually did? Right. Don't just give me the elements of the crime. Tell me what my client actually did. And Mark, they give those out like cotton candy in state court. Our friends in federal court are like, oh, that never happens. You're right. In federal court, it doesn't happen. But in New York State court, it happens all the time. And I'm going to give you the example that everyone here is using. It's burglary. So burglary is basically a trespass with the intent to cause a crime therein. And the prosecutors don't have to prove the crime therein beyond a reasonable doubt. However, they almost always tell you what the crime is therein.
Yes.
They trespass to commit a larceny, to steal something. They trespass to commit sexual assault inside the property. They trespass to commit a physical assault. Here, they did not do that. And look, I don't want to say
have to.
We've been saying
Arthur?
No,
it sucks. They should do it in the name of justice. I agree with you, Megyn. I agree with you, Arthur. I'd be livid as a defense attorney. The question is, why didn't the defense lawyers seek a bill of particulars to find out what theory the prosecution's relying upon?
They did, and in a very unlikely move or an unconventional move, judge said no. Well, by law, they don't have to do it, so I'm not having them do it. As opposed to, if I was the judge, I'd say, listen to me. We do it in every other case with some Tom, Dick, and Harry. You got the president of the United States here, a bill of particulars. But Judge Michon did not do that.
Wait a second.
Why didn't the defense? Let me ask you this. Let me ask you this, Mark. Let me ask you this, Mark. You're Todd Blanche, Trump's defense attorney. You try this whole case to the best of your abilities. He made some mistakes for sure, but to the best of your ability. Then it's time to do closings.
Yeah.
You're told you have to go first. You're like, what am I arguing? Can you say to the judge, you got to make him go first. I'm going to reserve my time for a rebuttal. Like, what do you do to preserve the record for an appeal, right? To start laying the foundation for my client's been deprived of his due process rights. There's a U.S. Constitution at play here. I don't give a shit what the statute says. This is wrong. I've never seen a prosecutor do this to a defendant, and I'm not getting up there and defending a case. I have no idea, even on closings, what it's about.
Okay, so you don't say all of that, but you say to the jury, look what they've done here. Add to the list of things that they've done, like getting into the detail of Stormy Daniels and all the things that they did throughout this trial, where it's win at all costs. They're not here to seek the truth. The worst thing is that I'm up here. We've all been here for weeks. We've been listening, and we don't know what this other crime is. They're going to wait until after I sit down to get up here to tell you. Objection sustained. I'm not saying that they have an obligation, but folks, if they're really here to seek the truth, if this is really about due process and the truth, they would have told us and not waited until I sat down. It's because they don't feel comfortable with this case. Put it out there, and I'd be able to tell you they didn't prove this case beyond a reasonable doubt.
So
I like that. Go ahead, Arthur.
Logistically speaking, the defense did know what the prosecution's theory is, because there was a charge conference last week. And in that charge conference, they requested and the judge gave the three theories: either violation of federal election campaign law, falsification
it's
of
a spaghetti against the wall. I have that. We're going to go through that in detail. But that is a spaghetti against the wall approach.
Said.
Like, it could be one of 20 felonies. I was saying yesterday, it could be New York law, it could be federal law, it could be Murphy's law. Have no idea. We're just going to say, like, any possible law. Like and by the way, he also ruled that the jury doesn't have to agree on which law was violated. 3 could think it was federal law. 2 could think it was New York state law. The others could think it was, I don't know, Irish law. I have no idea what they might think. Fine. So he had some knowledge. He was keeping the wide net as of Thursday. That's not good enough. Do you owe back taxes? Pandemic relief is now over. Along with hiring thousands of new agents and field officers, the IRS has kicked off 2024 by sending over 5 million pay-up letters to those who have unfiled tax returns or balances owed. Don't waive your rights and speak with them on your own. Tax Network USA, a trusted tax relief firm, has saved over $1 billion in back taxes for their clients, and they can help you secure the best deal possible. Whether you owe $10,000 or $10 million, they can help you. Whether it's business or personal taxes, even if you have the means to pay or if you're on a fixed income, they can help finally resolve your tax burdens once and for all. Call 1-800-245-6000 for a private free consultation or visit tnusa.com/Megyn. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.